Hey, I'm Paul Rabelais. I'm an estate planning attorney in Louisiana, and I want to go over what from a kind of nursing home and Medicaid standpoint could be a real trap for the unwary, particularly when it comes to making sure those successions get complete when a potential nursing home resident is an heir and the successions haven't been completed. Let me give you an example. You got grandparents, you got parents, and you got kids. So let's say grandparents passed away, could have been many years ago, could have been decades ago, and they owned a piece of property and they had two children, and either they had wills and left it to the children, or they didn't have wills, and by law, by our intestate law, it's going to go to the children. But the family never completed the successions. So from a title standpoint, that property is still in the grandparents' names. They never completed the successions because they never needed to sell the property, and kind of procrastination set in, nothing ever got done. Well, now their daughter, I'll call her mom, she's getting up there and she's got to go in the nursing home. She has a bank account with $1,500 in it. And so everybody in mom's support circle, mom's siblings, mom's children, they all think that mom is going to qualify for Medicaid, and Medicaid will cover that $6,000 or $7,000 monthly nursing home expense. Well, because they think that because mom's parents' successions were never completed, the property never got transferred to mom, so mom doesn't own it yet. It's not an asset of mom's. That's what a lot of people may think. But you know what happens when you assume? Remember the Bad News Bears movie? Here's the rule, and I'm going to read it to you. I got it up here on my screen. And the rule actually makes sense for reasons I'll explain in a minute. So this is the Medicaid rule as it relates to estate property. And Medicaid eligibility is a lot about what are the countable resources that a person owns when they're applying for Medicaid. And so I'm going to read the couple of sentences that are applicable here. In fact, I'll read one, stop, comment on it, then I'll read the other. It says, count the applicant/enrollee's share of an undivided estate as a resource the first day of the month following receipt. Well, you read that sentence, that sounds pretty good. Mom hadn't received it yet because the successions were never done. But you got to read the next sentence, which defines receipt. Receipt is deemed to be the day of death in the case of a direct descendant, or when there is an uncontested will designating the individual as beneficiary. So what that says is mom received the property the date her grandparents died, even though the successions or probate, call it what you will, even though those were not completed and title technically hasn't been put in mom's name. According to Medicaid, mom received it the date her parents died. So now the family's in a pickle because mom has $1,500. She's got to go to the nursing home. That's the place she has to be. And she's not going to qualify for Medicaid because Medicaid is going to correctly argue that mom owns one half of this piece of property because mom's brother owns the other half. And because that property causes mom's assets to go over $2,000, nope, not going to qualify for Medicaid. If she's going to stay in the nursing home, the kids got to pony up the money, or they just got to bring mom back home or live with the kids or whatever. But she's not going to be able to stay in the nursing home without paying the full freight every month, $6,000 or $7,000 a month, whatever that rate may be. So, and I get that that's the rule because Medicaid doesn't want to reward families for failing to complete successions. You always want to keep that title clear. And so they want to encourage families to get the successions done, get the property in the proper names. So now what does the family do? The family's got to scramble. Now they've got to get these successions done, which always takes at least months, if not more. They've got to perhaps sell mom's one half interest in that property. Her brother owns the other half. Then the family's going to have to spend that money down to less than $2,000 before they can successfully apply for Medicaid for mom. couple of things they're not going to be able to get away with. You know, they can't sell mom's interest for $1 because that's deemed a transfer, and that triggers a 5-year ineligibility for Medicaid issue. Mom can't refuse the inheritance as part of the succession and allow it to go on down to mom's children, because under our Medicaid rules, there's a rule that says if mom refuses or disclaims or renounces, call it what you will, it's treated for Medicaid purposes as if mom received it and then gave it away, triggering a 5-year penalty period from the time that mom, you know, took that action, which she hasn't taken yet. So they're really stuck. The ideal scenario, back when the grandparents passed away, the successions should have been complete. The property should have been transferred to mom and her brother, and maybe a decision would have been made at that time for mom to transfer her interest in that property to her kids, starting the 5-year penalty period. Or maybe a decision would have been made after the successions were complete. Mom and her brother sell the property, and then they can deal with the cash, or they'll have the cash to be able to pay for the nursing home. They won't be stuck in this bind that they're presently stuck in because they didn't know the rule. And look, most people don't. Nobody goes and peruses these Medicaid eligibility manuals, but I get the rule. It makes sense. And so the moral of this story is, you know, when that parent, grandparent, aunt, uncle passes away and you're a participant or a party to that succession, you need to really proactively get these things done so they don't come back and bite you for unintended reasons in the future. So hope that helps. A lot to it. Wanted to bring up that one issue, complete those successions. Just because the successions weren't complete doesn't mean it's not an asset that Medicaid states that the person owns successfully. So get those done. Hope that helps. One little issue in our estate planning world that comes up from time to time. Y'all have a good day.